started. Gracias por venir. Vamos a empezar. The purpose of this, there's like a funny little feedback thing happening, but we're going to be learning about our rights as commercial tenants. We're very lucky to have a lawyer from Brooklyn Legal Services Corporation A, who's going to explain more. We're here in the wonderful the Roost Cafe in the Lower East Side, African B. Basically, it's great to be here with all of you. We are going to record the legal service. It's already recording. Okay, great. I think that's all I have to say. I'll just say in Spanish. If no one is on the on the webinar for needing Spanish, maybe I'll just do it here. Okay, so no need to really explain.
Yeah, I don't see anyone. Yeah, I'll keep checking.
Okay, cool. Let me know. So yeah, with that, turn it over to Brian.
Well, I'll just introduce myself. I'm Brian Hanley. I'm a staff attorney at Brooklyn Legal Services Corporation A in the Commercial Lease Assistance Group. And I am going to be talking to you about understanding your legal rights under your commercial lease and renegotiating commercial leases.
I just want to introduce the whole team here. We're meeting up with Cooper Square Committee for the Commercial Lease Assistance Program that's funded by the Department of Small Business Services. Brian and I are both from Brooklyn Legal Services Corporation A, and we are partnered with Take Root Justice and Balls for this service. A little bit more about Brooklyn A, as Brian was just saying, we advance social and economic justice and community empowerment through innovative, collaborative, neighborhood-based legal representation and advocacy. And one of our major projects is the Small Business Support Project that we are here to talk to you about. And now I will hand it over to Brian to continue to give his expert legal advice.
Sure, and just as a quick disclaimer, this portion of the presentation is intended to assist commercial tenants in understanding their rights under the law and renegotiating the terms of their leases with their commercial landlords in the context of COVID-19 pandemic. This presentation is offered for information purposes only. The information contained in this presentation does not constitute legal advice and does not create an attorney-client relationship. All right, so I am going to talk to you about a few things. First, your rights under the law. Second, your rights under your lease. And third and fourth, and then I'm going to talk about familiarizing yourself with the rental market and initiating a conversation with your landlord if you are looking to renegotiate your lease. So the first thing I'll talk about is your rights under the law. So the first thing I'll say is just that most of your rights as a commercial tenant are dictated by the terms of the commercial lease. Unlike residential tenants, commercial tenants do not have many legal rights under the law, but there are a few things worth noting, and that's what we have listed here. The eviction moratorium, the moratorium on the enforcement of personal guarantees, and the tenant harassment law. So I will start with the commercial eviction moratorium. So the current eviction moratorium extends to May 1st. This started out as an executive order from the governor, but I think it was the beginning of March, the state legislature passed a law extending the moratorium to May 1st, and also adding a couple of provisions that are actually not described in the slide, but basically in order to enjoy the protections of the eviction moratorium, a commercial tenant needs to fill out a hardship declaration and submit it to their landlord. The way this works is that if the landlord wants to initiate eviction proceedings, it first has to send a notice to the tenant that includes the hardship declaration and explains that if they submit the hardship declaration, then they can commence eviction proceedings before May 1st. Next slide. Another law passed after the start of the pandemic was a moratorium on the enforcement of personal guarantees. So just a little background. Most commercial tenants will sign their leases as an LLC or an entity rather than in their personal capacity in order to limit personal liability. But if they do so, landlords will usually require the individual owner of the business to sign a personal guarantee, basically backing up all of the obligations of the tenant and saying that if the tenant fails to perform, then the person providing the personal guarantee will perform on behalf of the tenant. So the moratorium on the enforcement of personal guarantees basically just says that a tenant, if you're a commercial tenant and basically you were forced to close during the pandemic, then you may not be held liable for the tenant's failure to pay rent between March 7th, 2020 through March 31st, 2021. This hasn't been, to my knowledge, I think one court has confirmed that this is constitutional, but it hasn't been litigated much. So the meaning of this moratorium is still kind of murky, but it clearly does provide some level of protection to business owners who are providing personal guarantees. Next slide. And the third law I'd like to talk about, the commercial tenant harassment law. This is something that was in effect before the pandemic. It's basically just says that the landlord is not allowed to do take any actions that either would reasonably cause a commercial tenant to vacate the space, or they're not allowed to commit any what's called prohibited action. And prohibited actions include things like using force against a commercial tenant, changing the locks or otherwise preventing access, attempting to enforce personal liability provisions that they know are unenforceable, or threatening commercial tenant based on their perceived age, race, creed, color, national origin, gender, disability, marital status, partnership status, caregiver status, uniform status, sexual orientation, alienage or citizenship, status as a victim of domestic violence, or status as a victim of sex offenses or stalking. Next slide. So as I was saying before, most of your rights as a commercial tenant are going to be in the commercial lease. So it's important to understand this when you're negotiating the lease, to know exactly what the lease says, because that dictates what all your legal rights are. Like I was saying before, commercial tenants don't receive the same level of legal protections that residential tenants receive. So it's important to keep this in mind. Commercial leases can be long and complicated, but I'm gonna focus on four important provisions in the context of COVID-19, and they are default, security deposit, personal guarantee, and force majeure. Next slide. So the default provisions are basically the provisions that say that if one of the party violates the terms of the lease, the default provisions specify the procedures that the parties follow in order to enforce whatever remedies they have under the lease. Generally, failure by a commercial tenant to pay rent will constitute a default. However, it's important to remember that the landlord typically is required to provide notice to a tenant if they fail to pay, and in some instances, the tenant will be required, the landlord will be required to provide the tenant with an opportunity to cure the default. So it's important to understand what the party's obligations are under the default provisions, and make sure that they're basically following the letter of the agreement. Obviously, you need to look at what your lease says, but those are typical provisions. And you always want to make sure that you're available of like the timelines involved, like how much notice the landlord needs to provide before they can use their remedies, and what the cure periods are, if any. How much time does the tenant have to cure any default after the landlord has notified them? Next slide. So security deposit provisions. The one thing I want to say about this, obviously, I'm assuming you all know what a security deposit is. The one thing that happens often over the past year is that landlords have used security deposits to cover missed rent payments. It's just important to understand that if your landlord does that, there's a good chance that the lease will require the tenant to replenish the security deposit. So you'll have to pay them the amount back. The lease will say what the timeline is for doing that, and what the penalty for failure to do it is. But it's something that you need to be aware of if your landlord does apply the security deposit to the rent. I'm sure most leases will require the landlord to provide notice to the tenant that they've done so. But that's something that you need to keep in mind. Next slide. So the personal guarantee, this is what I was talking about before. For most leases, the lease will be signed by an LLC, and the landlord will require the owner of the business to provide a personal guarantee saying that they will satisfy the obligations of the tenant if the tenant defaults. So basically creates personal liability for the owner of the business. However, a lot of guarantees will include something called a good guy clause that basically says that if the tenant is not in default, and if it has been paying rent on time, and the tenant wants to terminate the lease and vacate the space, assuming the tenant and the guarantor have been keeping up to date on all their obligations, then they will not be personally liable for rent due for the remainder of the lease if they decide to terminate and vacate the space. Next slide. Force majeure. So a force majeure clause basically says that if there is some basically unforeseeable event that prevents either party from performing its obligations under the lease. So the examples we have here are pandemic, epidemic, government restriction. It could be, it could be some like a natural disaster, and anything that is just completely unforeseen that basically makes it impossible for one party to perform their obligations under the lease. A force majeure clause will basically release parties of those obligations if one of those things happens. Unfortunately, there is pretty much always an exception for the payment of rent, basically saying that even if a force majeure event happens, the tenant still has to go on paying rent. But it is worth checking the lease to see what this provision says. Unfortunately, in my experience, I haven't seen a case where a force majeure has released a tenant from liability, but it's worth looking. But yeah, unfortunately, it is the case that it's mostly a protection for landlords and not for tenants. Next slide. Okay, so I just talked about commercial tenants' legal rights under the law and under their leases. once you've familiarized yourself with your legal rights, but before you approach your landlord, we advise clients to familiarize themselves with the rental market. As obviously if the rent has gone down during the pandemic, but the tenant, is still required to pay higher rent under the lease, that could possibly give the tenant leverage to negotiate lower rent. Obviously, the landlord wants to collect some rent. If it knows that leasing the space out to a new tenant, they're not going to get as much rent, that gives them an incentive to negotiate with you. Since we're lawyers, we're not like real estate brokers or market experts. So we would generally advise our clients to contact a real estate broker to give them a sense of what the rental market is like in their neighborhood. Or you could just look at like online listings to get a sense of what a reasonable rent is. But that is something that could potentially work in your favor, and is something that you should know about before you approach the landlord. Next slide. Okay, so now we're going to talk about initiating a conversation with the landlord. Next slide. So there are a bunch of things that you want to think about before you start the conversation. One is just how far behind are you on rent payments, and basically how much do you owe in arrears. Unfortunately, the more you owe, the harder it's going to be to satisfy those obligations, which will leave you more vulnerable to eviction and non-payment proceedings once the moratorium is lifted. However, most landlords understand that collecting something is better than collecting nothing. And if they don't work with the tenant, they're unlikely to get any of the amounts owed. So you're not completely without leverage, but that's how much you owe is obviously one thing that you need to think about. Another issue you need to think about is whether you signed the lease in your personal capacity or as an LLC. Like I was saying before, most commercial tenants sign as an LLC and then sign a personal guarantee, but not all do. So if you signed as an LLC and you do not have a personal guarantee, that will obviously put you in a much better position to negotiate, because the landlord cannot go after you, basically. And the last consideration, obviously, you need to think about how much you can afford to pay your landlord, whether you're trying to make a partial payment to cover past arrears, or whether you're talking about how much you're able to pay on an ongoing basis in the future. Obviously, you need to consider your financial obligations, your revenue, any other sources of capital. You also need to think about when the timeline for making payments. You can structure it however you want and be as creative as you want, but you can either make a lump sum payment when you sign the amendment, or you can make a monthly payment, or you can make a monthly payment that's like a portion of your revenue. You can be as creative as you want in terms of figuring out how and when to pay whatever it is you're paying. I was about to say next slide, but that's my job. Okay. So when you are reaching out to your landlord, obviously you're going to want to explain your circumstances, explain, you've been closed for several months, if not more, of the past year, and that you haven't, even when you are open, you haven't been able to get the same kind of business that you did before the pandemic, and that you've basically just explained that you've been making diligent efforts to bring in whatever revenue you can and to pay whatever you can. and just make it clear that you're not just taking advantage of the circumstances, that you're really doing everything you can to stay in business and continue to pay rent. And you also, like I was saying before, you want to keep in mind that they, in most cases, will have an incentive to negotiate. They, like I said, they want to be able to collect something and not nothing. The landlord I'm talking about. And they will, in most cases, know that the amount of rent they will be able to get from a new tenant, if they did evict you, may not be as much as what you're paying. So they will generally be willing to come to the table to negotiate. Next. And the final thing I want to say is that after you've spoken with the landlord and had some kind of back and forth on what kind of agreement you want to come to, it's important to make sure that you always get that agreement in writing, signed by both of the parties. We have had clients who negotiate rent amendments with their landlord, but then the landlord will agree to something in an email, but not want to put it in a document and sign it. But it's always best, if possible, to put it in an actual written amendment that gets signed by both the parties. And in terms of drafting that amendment, a few things to think about. If you have a rent abatement, you obviously want to specify what the new monthly amount is going to be and how long you're going to be paying that amount if it's only temporary. If you're doing a rent deferral, you want to include a schedule saying when you have to start repaying whatever the amount owed is. You want to be clear about what the schedule is. And if you have provisions dealing with past arrears, it's important to specify in the lease amendment what the total amount owed is. You want to specify the exact amount that the landlord is waiving, if anything, and you want to specify what the remaining balance that you owe is and how you're going to be paying it back, when you're going to be paying it back, what the schedule is. And yeah, that's the end of my presentation. I don't know if Ashna, you wanted to do questions now, or if there's something else you wanted to do first.
Any questions for our attorney?
Any questions, guys? You want to open it up, John?
Repite la pregunta.
No worries.
La pregunta es que si tengo un lease,
We have a
una
question, Brian.
extensión de 5 años más de lease, si se puede vivir sin penalidades esos 3 años, 3 depósitos.
Okay, so she's saying if you have a 5-year extension on your lease, and you're unable to pay rent in the moment, can you use the security deposit to pay some rent during that time?
Ryan, could you hear?
I'm sorry, I'm having trouble hearing. You have a 5-year extension. Can you use the security
A
deposit?
5-year, sorry. Yeah, can you use the security deposit to pay some of the 5-year extension? It would depend on the lease and you have to take a look at it.
Do you mean to pay the rent during the extended term?
Yes.
Typically, a lease is not going to say that a tenant can use that money, the security deposit, to pay the rent. Normally, what would happen is that if you miss the payment, the landlord might take that money and use it to pay it. But obviously, like I said, you always have to look at what your lease says. But generally speaking, the security deposit funds are not available to the tenant to be used as they would want, unfortunately.
So, desafortunadamente, usualmente no es posible, pero el dueño de la propiedad podría usar este dinero para cubrir la renta, pero como dije, depende de cada área.
Entonces, ¿para qué se utiliza un security?
What deposit then?
Ryan?
If you can't use it to pay rent, what's the security deposit for?
It's basically there for the landlord's benefit and not for the tenant's benefit, unfortunately. So it's there if you miss a payment, if there are any other expenses that the landlord has as a result of any tenant breach under the lease, that's what it's there for. Unfortunately, it's not there for the benefit of the tenant.
It's usually used after you move out.
Oh, yeah, so that's a deposit is can use to pay your balance if you move out, but it can't
But
pay the
even that,
balance
they'll
while
take
you're
it, they'll say
there.
you owe taxes, you made damages.
Brian, is that something that our attorneys have been able to negotiate? Have we been able to use security deposit for back rent in the last year?
Oh, yeah. Yeah, absolutely. It's just not, the landlord can do whatever they want under the lease technically, but absolutely having them apply it to rent is very common. I'm just saying the lease will not necessarily require the landlord to.
Right. But we could get our business owner an attorney who could potentially put that on the table.
Absolutely, and that it is very common to have to get the landlord to apply the security deposit to back rent. I was just saying that the lease doesn't necessarily give them that right.
Según el contrato de arrendamiento, el depósito es para el beneficio del dueño de la propiedad, no es para el inquilino, no para pagar renta no pagada. Pero en el último año han podido negociar acuerdos para
Básicamente todo depende de la comunicación que tenga yo con el dueño para poder negociar esto. Sí.
y tener un abogado ahí también, que puede leer el lease y entender todo y explicar todo y desarrollar una estrategia para hacer
Ok.
una
Yo
acuerdo.
soy muy preguntona, sorry. Pero la próxima pregunta es si uno como dueño no puede continuar un lease, entonces, ¿qué va a pasar con, en nuestro caso está bajo una corporación, bajo la corporación está el esposo, ¿en qué le afecta a la persona que firmó? ¿O cuáles son cuáles más bien son nuestras responsabilidades con el lease? ¿Hasta cuándo se va a terminar? Porque esto creo que no termina hasta que no termina el lease.
Ajá. Entonces, otra vez, ¿cuál es?
La pregunta es que si una vez que uno como individuo no puede ya, ni como individuo puede uno pagar su renta, si como corporación no puede, como individuo menos, ¿qué va a pasar con el lease?
Okay, so what happens if the corporation can't pay the lease and the individual can't pay the lease? What happens with the lease?
So if the entity can't pay and then the guarantor, you mean, can't pay, the individual guarantor? Well, then they just can't, then the landlord just can't collect what it's owed. What I guess what most people would end up doing is filing for bankruptcy. Basically what that does, I'm not a bankruptcy expert, but what an individual bankruptcy would do is it would take your assets and it would use them to pay whatever debts you have, and whatever debts can't be paid get discharged. So ultimately, if they can't collect from the individual, then they're not going to be able to collect.
Si el dueño no puede desde el individuo, la corporación y el individuo, el procedimiento de bancarrota es una evaluación de todo lo que tiene como dinero y otras cosas, y si todo eso no va a utilizar eso, y luego si el dueño no puede colectar, este es el fin.
Gracias.
Guarantees aren't enforceable, personal guarantees.
Brian, what's happening with the personal guarantee law, and has it been extended?
Not that I know of. And I haven't I haven't seen any cases where landlords have actually enforced guarantees over the past year. So I don't know exactly what would happen in practice if they tried, unfortunately. But I'm not aware of it being extended.
Okay, and right now it's till May 1st?
the guarantee, let's see, the moratorium on enforcement of personal guarantees only goes through March 31st. So failure to pay rent between March 7th, 2020 and March 31st, 2021.
Thanks, Brian. Any other question here? I'm gonna sign you both up for the program.
Okay, cool.
Okay. Thanks,
Brian,
Brian.
thank you so much.
All right, thanks everybody.